told you earlier that the Speaker is challenging the Supreme Court's ruling, and that's what's happening in court as we speak. Let's take you there live.
Well, there are members of parliament, if they can in Canada get up and say it is official, it's fine. Yeah, it is fine. It's good with me.
Yes. Lord, with respect, we are vehemently opposed to the application, and we rely
Mr. Afenyo, you have to hurry up. We would like to take your time.
Very well.
I always have to regulate Mr. Sorry because he tumbles his words out. But also you pull them out. So now, don't pull them out like that.
Very well, I'll try to speak up. My Lord, with respect, we do so by relying on our affidavit in opposition filed.
May I find out whether Mr. Gatti has once again relinquished his privilege?
My Lord,
because we will not allow you to argue half and leave half to Mr. Afenyo. It will not happen.
I appreciate that.
So have you relinquished your...
argue this.
Thank you.
If subsequently there's another matter.
Thank you very much. Mr. Afenyo, please continue. Your 10 minutes are running.
Very well. Lady, we oppose the application by relying on our affidavit in opposition filed on the 29th of October 2024, and we rely on all the depositions therein. Of notable concern to us is our paragraph 4, which is a counter to the contention by the first defendant applicant that the procedure adopted by us in commencing this action is questionable.
Is this the affidavit of John Bossman?
That is so, my Lord.
Go on.
Lord, in doing so, we wish to advert the mind of the court to rules 45 and 46 of CI 16. Which is a provision on procedure for invoking the original jurisdiction of the Supreme Court. The rule provides that any such invocation shall be commenced by a writ and not an originating motion, and we were accordingly guided. The rule further provides at Order 46 that it must be accompanied by a statement of case. Rule 46. We're talking about Rule 46 of CI 16.
Yes.
That it must be accompanied by a statement of case. And, my Lord, we accordingly complied. My Lord, our second objection regards the nature of the reliefs sought by the plaintiff. It has nothing to do with Article 99, Clause 1 of the 1992 Constitution. It was a plain and simple case of invocation of the original jurisdiction of this court for interpretation of Article 70, Article 97, Clause 1, G and H. And my Lord, we have paid painstakingly stated this in paragraph 10 of our affidavit in opposition, as well as 11. My Lord, our third ground of opposition is contained in paragraph 13 of our affidavit in opposition, where we insist that the service of our writ and the motion on notice for interlocutory injunction on the Speaker of Parliament through the legal office of Parliament was good service. Despite the fact that it was left on the table of the officer who received the processes. This was a day before the ruling of the Speaker of Parliament. It was done on the 16th of October 2024. And the Speaker went ahead to deliver his ruling on the 17th of October 2024. So our humble contention is that at the material time incidental to the delivery of the ruling, the Speaker was fixed with knowledge of the pendency of the action before this Honorable Court. Yet he went ahead in disregard. My Lord, our fourth ground can be found at paragraphs 18 and 19 of our affidavit in opposition, where again we've taken the pain to state that the order of this Honorable Court on the 18th of October 2024 granting a stay of execution against the ruling of the Speaker of Parliament does not amount to any interference with the procedures and business of Parliament. My Lords, per Article 2, Clause 1 of the 1992 Constitution, an invocation of the exclusive original jurisdiction of this apex court is the right of every citizen of Ghana. More so when the applicant in this instance is the majority leader and the leader of the majority caucus in Parliament. He had an inherent interest in the said decision of the Speaker of Parliament, and for that matter, had every right, my Lord, to seek justice from this august forum.
But you know that under Article 2 actions, you don't even need to have an interest.
Exactly.
Your community of interest is with the Constitution of Ghana.
Exactly. So, my Lord, the point we seek to make
because this point that you are making, I don't think it adds anything to this.
Very well. So, my Lord, we say that guided by the Constitution, he need not show any interest. But even so, he had an interest. My Lord, this is further fortified by Article 132 of the 1992 Constitution, which vests this Honorable Court with authority, with supervisory jurisdiction over any adjudicating authority in Ghana regardless of being a separate arm of government. Lord, our faith ground is contained in paragraph 21 and 22 of our affidavit in opposition, giving our justification for resorting to an ex parte application. Paragraph 21 and 22 of our affidavit in opposition. Lord, we have stated therein that we could anticipate potential irreparable damage and mischief if the order was allowed to stay. And this action was to commence in the ordinary way. Lord, we fortified our submission by relying on Order 25, Rule 8 of CI 47. Lord, the said Order 25, Rule 8 identifies of CI 47. Lord, a minute. Lord, the point we seek to make is that, my Lord, 1:8, very well. Very well. Lord, I'm good. 1:8. Very well. Lord,
and just for the record, read it. You don't have CI 47 there? Then can you move on? We've helped you by telling you Order 25 Rule 1:8, yes, not 25:8. So you can move on. Please, your time is up.
Very well. Lord, what we intend saying over there is that there was an element of urgency. There was an element of urgency associated with the application and the need for a dispatch response. Moreover, any mischief achieved by the ruling of the Speaker was irreparable, considering the fact that those 4 constituencies would have been bereft of representation in Parliament between now and its dissolution. my Lord, per Rule 5 of CI system, this honorable court is the only court of the land seized with the power to prescribe rules of practice and procedure. So regardless of the fact that granting an ex parte application for limited number of days is not stated in the rules of the Supreme Court, my Lord, the court was all the same, vested with the power to make the order it made. And nothing unlawful, unprocedural could be raised in respect of the order of the court. More so, my Lord, Article 2, Clause 2 of the 1992 Constitution give this honorable court the power to make appropriate directions that it may consider appropriate for giving effect or enabling effect to a declaration. My Lord, we're saying that in so long as those affected members of parliament were not given the opportunity to state their side of the story before the speaker made his order, the rules of natural justice, the Audi Outram Partem, was breached. This was a statement made by a member on the floor of Parliament. This was a statement made by...
I think you're going too far.
Lord, I'm rounding off. This was a statement made by...
I think you're going too far.
Very well.
We can only limit ourselves to what is before us.
My Lord, the capacity of the plaintiff is questioned.
You have responded to that.
Yes,
very well. You said, if you don't mind, I can read what you said.
Very well.
I can read what you said. The invocation of the jurisdiction of this court is the constitutional right of any citizen.
Very well.
That's one to Article 2.
My Lord, in that circumstance, then I crave your indulgence to round off my argument.
So you are done?
Yes, I'm rounding.
Thank you.
That, my Lord, all said and done. All said and done. Lord, all said and done.
There are many people here who are not here because of this case.
I know.
Their work needs to get done.
Lady, I'm sorry. All said and done, it is the standpoint of the plaintiff, respondent in this case, that he has not breached any procedure in seeking the order which is now being sought to be set aside. Neither is his action in breach of any substantive law or the Constitution governing the Republic, but granted without admission that there was even one. Rule 79 and Order 81. No, Rule 79 of CI system and Order 81 of CI 47. My Lord, makes it curable by this honorable court. Lord, I rest my case. I'm grateful. And my Lord, whether executable or non-executable, an order of stay is made to operate. And Obrenu Kwisata versus Ghana Telecom It's not far-fetched on this scope.
They should be opposed to the application, rely strictly on points of law. They should, before I proceed, may I respectfully announce a reconstitution of our representation. It's been joined by the Deputy Attorney General, Dana Asunabadapa. So it's a full house. The Office of Attorney General is properly constituted. We submit that the instant application is offensive to the rules of procedure of this honorable court, is unknown to the laws governing the administration of the court. The first point we make respectfully is that the Constitution has set out in clear terms the manner in which a challenge to the decision of the court can be made. This application completely violates the laid down procedure for challenging a decision of the court in the Constitution. Article 153, clause 1. 153, clause 1 of the Constitution vests the Supreme Court with power to, and I quote, review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by rules of court. Respectfully, the instant application seeks an order setting aside the process and proceedings of the court and vacating the order of the court. Respectfully, the decision in question was an exercise of right. Respectfully, as if you wanted to say clause 1, the review, as it's 133, I'm sorry. 133, the review decision of the court. Especially, my contention is that this provision is a rule under which a person aggrieved by a decision of the court comes by to seek a review of operation of the decision. The instant application is not an application for review. It doesn't invoke the court's review powers, and is therefore unknown to the laws governing the decision of the court. Especially Article 134 also vests the Supreme Court with the same powers of review of a decision of a single justice. Indeed, the decision in question was not by a single justice. But the point I seek to make is that whenever a decision of the court is being sought to be reviewed, varied, or discharged, the procedure for doing so is as set out in the Constitution. And this is not an invocation of any of those procedures. Especially the second point we make is that the application mixes up grounds for a substantive defense to the action with matters that, in the view of the first defendant, constitutes a basis for a setting aside of the service. And this respectfully is wrong. The court will notice that on the face of the motion paper, the grounds for the application are stated as, and I respectfully I'll quote, I'll just be quick about it. The rate by which the plaintiff has purportedly invoked the court's original jurisdiction is incompetent. The court has no jurisdiction to entertain the suit before the court. The court has no jurisdiction to stay execution of a ruling of the Speaker of the Parliament of Ghana. Respectfully, paragraphs 12 to 18 of the affidavit in support also raise matters which constitute a substantive defense to the action. And I respectfully will quote paragraph 12. So the words used in Article 97, clause 1, paragraphs J and H of the Constitution are clear unambiguous, and have no disputed meaning, and no basis exists in the processes filed for assuming that there's dispute. Then paragraph 13. It says the words used in the provisions of Article 97 clause 1 paragraphs J and H simply mean what they say. That's to say, when a member of parliament leaves a party on a ticket of which they are elected to parliament to join a political party or to become an independent member of parliament, or when a member of parliament elected as an independent member of parliament joins a political party, they shall vacate their seat. Especially, I will turn over to paragraph 29 to 32 of the affidavit in support. And again, they constitute substantive defenses to the action.
Number Attorney General, you know you have 10 minutes.
Yes, please. My lady, I'm still well within it. I'm sorry. So, it says, paragraph 31. Further, the 19th Constitution of the Republic of Ghana provides for the well-known separation of powers doctrine, whereby the scope of the powers of each arm of government is set out, and no arm of government is expected to overstep its bounds. The same is repeated in other parts of the affidavit. So the point I make respectfully is that when a defendant takes the view that the writ does not invoke the decision of the court because in the view of the defendant, the words of the Constitution are clear. The rules do not permit the filing of an application to set aside the writ on that basis. Indeed, the grounds for such a contention will have to be in a statement of case filed and the point raised for determination by the court. And the court will notice that indeed that issue is actually one of the issues set out by the second defendant for determination. The second defendant does the Attorney General file issues for determination in this matter, and those are issues raised in the for determination by the court. Especially, indeed, the application completely misunderstands and misconceives the Supreme Court's original decision. And I made the point that, indeed, the court would notice that Article 2, Clause 1 of the Constitution constitutes the principal mechanism, with all respect, for enforcing the Constitution. And in examining Article 2, Clause 1, I pray the court not to look only at the article, but to even read it with Article 3, Clause 1 of the Constitution. Article 3 of the Constitution, Article 3, the whole of Article 3 of the Constitution, imposes a duty on all citizens to defend the Constitution at all times. Respectfully, there is no better mechanism for defending the Constitution by seeking an interpretation of the Constitution whenever a provision of the Constitution is in contention or a controversy has arisen in respect of that provision. Clearly, the meaning of Article 97, Clause 1, paragraphs J and H, as advanced by my learned friend, Counsel for the First Defendant, on which he says are clear, have been contradicted by the plaintiff in this case. And indeed, I have also duly filed a civil case in it, and totally, his understanding, with all respect, is wrong. There cannot be a more demonstrable case for a controversy as having arisen in respect of a provision of the Constitution than the instant case. My respectful submission is that indeed it will be a recipe for chaos, lawlessness, and a danger to the security of the state for a person to contend that merely on account of his own understanding of the Constitution, which he says are clear, a writ issued duly invoking the decision of the Supreme Court has to be set aside. That would be the basis for lawless conduct. And this honorable court owes a duty not to encourage it. I'm fortified in this proposition by the locus classicus on the matter before an Attorney General reported in 1980 Ghana Law Report at page 637. It is where the Supreme Court stated clearly that whenever a controversy has arisen in respect of a provision of the Constitution, it is a basis for the invocation of the court's original decision. Respectfully, the points I make today are not points being sought to be established today. They are matters that have been long established 40 years ago in this honorable court. My lady, I quote from page 650 of the provision. And indeed, it was also a controversy regarding a decision by Parliament. Parliament had actually made a decision to subject the Chief Justice of the Republic to vetting. The Chief Justice had also even acceded to that process. The Supreme Court said that, notwithstanding the Chief Justice's decision, insofar as that decision was unconstitutional, it could form the side matter of the original decision of the Supreme Court. But the court stated that there's a controversy regarding the status of the incumbent Chief Justice, the determination of which depends upon our interpretation of the Constitution. Once there's a controversy, a justiciable issue, we believe that under the wing of interpretation as contained in paragraph A of clause 1 of article 118, the court has reason to detain the issue raised by the plaintiff's right, and the plaintiff is thus properly before the court. And respectfully, the court went ahead to make the point that in a constitutional action, the community of interest is with the Constitution. There's really no such thing as a plaintiff and defendant, and therefore the writ which mentioned some members of Parliament, there must be a demonstration of an interest in them. There's no such thing as that. Indeed, the plaintiff, with all respect, could have omitted reference to any member of Parliament and have just stated a question for determination by the court, whether upon a true and proper interpretation of Article 97, Clause 1, paragraphs J and H of the Constitution, a seat of a member of Parliament becomes vacant upon the occurrence of A and B. And that is it. And the court would have been seized with the decision. My lady, the first defendant makes reference to an alleged denial of the right to a hearing on the time pattern by the filing of a motion ex parte. My respectful quick answer is that indeed the law even envisages such a procedure, and there cannot be a denial of any natural justice, right to natural justice, in the court entertaining an application for application ex parte. And if indeed it was the case that whenever a motion ex parte is brought, there is a denial of the right to a hearing, then indeed the court ought to scrap from its procedures and rules motions ex parte. This submission is totally incongruous, totally offensive to the long or the age-old practice in this honorable court. Respectfully, I would respond to the contention made by my learned friend that there was an understanding of the CJ with the Speaker of Parliament and all that. I will not seek to even go into the merits of the understanding. But the point must be made that constitutionally.
No, hold on, please.
Right.
I think that for the benefit of the public
right.
of this nation,
Right.
it is important to address the facts behind that matter.
Right.
SBB. D. Because there had been a circular in 2021 to regulate service on members of Parliament. And indeed, the Speaker of Parliament invited me as Chief Justice to discuss the return to that regulation. So I reviewed what my predecessor did, and I issued a circular. If anything, I think your submissions may address the import, the legal import, and nothing more.
Right. Lady, in addressing the legal import of that circular, I would note respectfully that I'm just looking for a circular, that what is paramount before the court in an action of this nature is the proper interpretation of the Constitution. And indeed, as held in before an Atejera, even if, assuming we had written, even if the CG had written such a letter, for me, with all respect, it's immaterial.
A circular.
The circular, written such a circular, it is immaterial for me. It is a construction of the words of the Constitution that matter. Before Atejera even indicated that this Chief Justice, who had lent himself to the process, which was subsequently pronounced upon as unconstitutional by the court, could not have waived any right whatsoever, because there's no such thing as extra under the Constitution. And I look at the provisions, the words in Articles 117 and 118. All it says is that civil or criminal processes coming from any court or place as of Parliament shall not be served on or executed in relation to the Speaker or a member of the Clerk of Parliament while he is on his way to attended at or returning from any proceedings of Parliament. In my respect, I do not see Monday in Article 112, 117. I do not see Monday there. I do not see Tuesdays to Friday. I do not see. All that must be understood clearly. Irrespective of that circular, in my respect, I, the Attorney General, can, or any citizen of the land, having a vote in front of the Supreme Court, can serve the process on a member of Parliament, the Speaker of Parliament, or a clerk to Parliament, except when he is on his way to Parliament or returning from Parliament. That's what it says. But again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and what have you, that Parliament of Ghana.
I don't have the right of reply. That is it. It's done over 25 minutes. Yeah.
Attorney General, you have 1 minute.
But I don't have the right to reply, especially that he got up only on points of law. So but he's exceeding.
Please sit down.
Yes, the point of law I made because the application.
Please don't waste your 1 minute.
But the point I'm making is that the Supreme Court's judicial review powers, pursuant to Articles 2 Clause 1 and 130 Clause 1, extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual is exempt from it. Indeed, the President himself is even subject to Supreme Court's judicial review powers under the Constitution. And the Constitution spells out the consequences for a failure to obey decisions and orders and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high command under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. So clearly, the powers of the court can never be questioned at all. And it is for this reason that the Supreme Court, in before an Attorney General and further fortified by J.H. Mensah and Attorney General, reported in 1996 Supreme Court of Ghana Law Report, stated clearly that in Ghana, there's even no such thing as a political person. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my left friend, Counsel for First Defendants, that it was an administrative decision of the Speaker. And so, with all respect, I'll ask, and so what? Any administrative decision of a person or authority which comes in contravention of the Constitution is amenable to the court's judicial review powers. I strongly submit that the application before you is totally offensive to all rules and procedure of this honorable court, is unknown to the laws of Ghana, and must be dismissed. I pray accordingly.
Just some short points of law, especially that they were made for points of law, and I'll be very short. First point, that the application is unknown to any rule of procedure and offensive and all of that. That's the simple answer. Since the days of Mosi and Bajina, elementary first rule in the civil procedure class is that if an order is a nullity, you can come by any procedure to set it aside. It remains the law following from that. He likes to cite cases of vintage. He says over 40 years. You calculate when Mosi and Bajina was decided, 1963.
Mr. Sorry, all your juniors are here.
And they were here when they said there is a misconception and a misunderstanding. They have remained here. And this is the clearest example of a misconception and misunderstanding. I said from 1963 up to 2000, and we are now in 2020 something. It remains the law, elementary first rule. 2, that I'm challenging the jurisdiction of the courts, and I'm saying, with all due respect, some matters don't fall within the jurisdiction.
Some matters do not.
That this matter doesn't fall within the jurisdiction of the court, and that I'm mixing matters that should go to the defense and then an objection.
Now, the point made
yes,
is that if you are urging that the writ is incompetent,
yes,
that should be separated
yes,
from submitting a defense to the substantive action.
Okay.
That's one.
yes,
Second, that if this court gives an order and you wish for it to be vacated, reversed, varied, discharged, the onus is on you to bring an application under the review jurisdiction of the court, and not an application such as you have crafted.
yes, ma'am.
That's the point.
And I'm saying that the tried principle of civil procedure is that the rules of review aside, this court delivers judgment according to 3 main yardsticks: statute law, common law, and the well-known practice of the courts. That has been consistent. And the well-known practice of the court and the common law is that you come and set it aside. And I'm saying way back from everything up to date, that remains the law. So this is not a point. Secondly, if I am challenging the jurisdiction of the court, there are 2 ways and several ways, elementary civil procedure. I can take it in limine or put it in my defense, and I'm taking it in limine. Another elementary point. Now, let me just deal with the Article 2(1) point tendrously said, in all of the cases involving Article 99, the jurisdiction of the court to determine a membership of Parliament, they also come under Article 2(1). But the court has always said that yes, if they didn't invoke Article 2(1), they wouldn't have been here. But the court has said, look, we will keep our streams clear. Then you cite to for an Attorney General and about the fact that if a matter is within...
Your 1 minute is up.
Well, there are other cases. Also say, more recent vintage, they all say clearly that that would not be a reason for the court to entertain jurisdiction. And as for the circular, my Lord, the Chief Justice must have had reason to issue it, and the Speaker must have had reason to respect it.
And it has constitutional power.
If it's not constitutional, he knows what to do. He should come and declare it unconstitutional. But otherwise, then the Speaker should feel deceived by it. That is the point.
You are done.
I'm done. But if my time was happening.
The case is stood down for the court to rule.
All rise. Benjamin, please tell them to switch it off. Tell them to switch it off. Please now, hurry up. They should switch it off because why are you filming whilst we are going to
from both the lawyers for the Speaker of Parliament, Thaddeus Sorry, lawyers for Alexander Markin, and the first has also from the Attorney General, and he is set to deliver a ruling on this application. Mind you, for our viewers who are just joining us, this application is an application by the Speaker of Parliament seeking to vacate the ruling of the Supreme Court 2 weeks ago that stayed the ruling of the Speaker of Parliament declaring falsehood vacant. After the Speaker of Parliament declared falsehood vacant, the majority leader came to the Supreme Court and got the court to stay the ruling up until the substantive matter is dealt with. The Speaker of Parliament says that ruling was incurably flawed, for which reason it must be set aside, and the Supreme Court has been hearing arguments. But even before these arguments will be heard and this stage will be reached, the lawyers of the Speaker of Parliament have made an application seeking to get one person to leave the bench. That is Justice N.S. Yaugaiwu. It is on the record that the former former parliamentary candidate of the NPP in 2012 in the Volta region constituency there. The Speaker of Parliament lawyers wanted him to recuse himself. The court declined and said this is a matter of constitutional interpretation, has nothing to do with political parties. Among other reasons, decided that Justice N.S. Yaugaiwu was properly so-called a part of this constituted panel and should continue to hear this matter. So some of the arguments have been by Thaddeus Sorry. He says that the writ was incurably flawed. The writ is the document and the procedure used by Alexander Afenyo Markin to come to court. He says that is incurably flawed. It could not have been used in this instance. Again, he says the court lacked jurisdiction and that this matter should have started from the High Court by virtue of Article 99, and it's a matter of evidence to the High Court and not the Supreme Court. Again, he says that could not have stayed the ruling of the Speaker because the Speaker's ruling was not a judgment of the court to be stayed in this case, for which reason they took this decision. And then they again talked about the ex parte application in breach of natural justice and among others. So another court is said to come in here, different matters in this matter. New panel is now walking into here different matters, and then the court will refer to the original case to be able to offer a ruling on that. So.
Thanks for staying with us here on the Jaw News channel. Live visuals from the Supreme Court. Thaddeus Sorry contended the panel of the Supreme Court. If you just tuned in, the Speaker of Parliament is challenging the ruling from the Supreme Court filed by Alexander Afenyo Markin, the majority leader, that sought to stay the execution of the Speaker's ruling. If you recall, the Speaker declared 4 seats in Parliament vacant. Alexander Afenyo Markin went to court seeking interpretation of Article 97 of the Constitution. Now, as part of the reliefs he was seeking in court, he also requested that the court restrain the Speaker from declaring those 4 seats vacant. Now, as at the last time the Speaker adjourned the House indefinitely, the court had served the Speaker with its ruling, ensuring that the Speaker restrains himself from declaring those 4 seats vacant. Now, the Speaker is in court contesting that his lead counsel, Thaddeus Sorry, is actually contesting the makeup of the panel. The Chief Justice, as well as 4 other justices of the Supreme Court, they are here in this case. And Thaddeus Sorry is contesting that a specific justice of the Supreme Court, which is N.S. Yaugaiwu, should not be part of the panel. He alleges that he is linked to the NPP, and because he has linking to the NPP, it constitutes conflict of interest. The court has ruled on that, dismissing his claims. The Attorney General also contested some key portions of the affidavit filed by the Supreme Court. By Thaddeus Sorry at the Supreme Court. He contested some of the key portions, especially 21 and 49. He raises concerns about the makeup. He says that it is wrong, it ought to be struck out as it is contentious. Well, that's the update about what is happening in court, and the fate of that case will be decided. Why is this important? This is quite important because it will then determine who is majority in the House. We'll take you back to Parliament when the ruling commences after this break.